Welcome everyone to our webinar on resolving director disputes, essential strategies for small business owners. My name is Jodie Thomson and I'm a practice leader in LegalVision's disputes team. I'm joined today by my colleague Nina Vanderlaan, who's a senior lawyer in LegalVision's corporate team. Before we begin, just a couple of quick housekeeping items. You'll receive the recording of today's webinar and the slides in your email. If you have any questions, you can submit them in the Q&A box and we'll try and answer as many as we can at the end of the webinar. And we'd be very grateful if you could complete the feedback survey after the webinar. Also, all attendees today are eligible to receive a free consultation with us to discuss how we can help you with your company, any disputes, contracts, or any of your other legal needs. To request your free consultation, you can provide us with your contact details in the survey that appears at the end of the webinar. So today, we're going to be discussing the most common director and shareholder disputes and issues that we see among clients and companies. Briefly, we will be covering the differences between directors and shareholders and how those different roles come into play in disputes. Some of the most common types of disputes that we see, some steps to avoid directors' disputes, the first steps to deal with a rogue director or something going wrong within the company, within the management team, how to work towards a resolution outside of court, and if you do need to go to court, some advice on going to court with a director or a shareholder dispute. Then we'll have some Q&A at the end. Again, please submit your questions throughout the webinar and chat function and we'll answer them at the end. So I will get started and I'm going to start off by giving just a brief overview of the differences between directors and shareholders. I'm sure most of you are aware of this, but it can make a big difference when we're actually looking at legal rights and obligations and options to manage a dispute or if things go wrong. Essentially, a shareholder is the owner of the shares of the company and can vote on the strategic direction of the company. The director, however, has responsibility for the day-to-day management and the business activities. You can be both a director and a shareholder, and in many of the disputes that we see, which are smaller to medium-sized companies, then that's often the case. The directors are also shareholders. But we also see those parties as employees or contractors because they're working in the company in some way. The types of disputes that we see are very varied, but there are some common threads. We often see a falling out between one or two or more directors where they might claim that one of them is not necessarily pulling their weight or doing what they're supposed to do as a director in running the company. There might be a misappropriation of funds, spending company money improperly. There might be one director excluding the other director or directors from access to the business and the books, maybe trying to run things themselves and not sharing information properly. Likewise, excluding others from meetings or decisions about the company. Perhaps one director is not keeping proper books and records, which is a requirement under the Companies Act. And likewise, spending money irresponsibly or entering contracts or making decisions about the company that may not appear to be in the company's best interests. One of the most common disputes that we see, again, in smaller to medium-sized companies, and is a really tricky one to resolve legally, is where there's a 50-50 deadlock. So, for example, you might have a small company with only two directors, and those two directors are also 50% shareholders. So it's impossible for one to vote the other one out if that was an option in the company processes. And any kind of resolution requires an agreement between the parties, which might be difficult. The types of legal claims that can arise out of a disagreement or a falling out between directors and shareholders include shareholder oppression, where a shareholder might claim that a director or other shareholders' actions are commercially unfair towards them. There's a whole range of different types of conduct that can fall into oppression. And in fact, oppression claims are the most common ones that we talk about when we're looking at legal options for clients. But also a breach of a director's fiduciary duties. And they're the core duties that a director owes to the company, that at all times a director must be acting in a way that is in the best interests of the company. And we, often have claims involving all of the above. I'll hand over to Nina now to talk about the next slide.
Thanks, Jodie. I'll now talk through some of the practical steps you can take and safeguards you can put in place to avoid a director's dispute down the line. So the first big one, and Jodie just alluded to it before, is making sure that you as a director and the other directors on your board know your director's duties. The duties that apply to directors in New Zealand are listed here, and are the duty to act in good faith and in the best interests of the company, the duty to exercise your director powers for a proper purpose, the duty to comply with the provisions of the Companies Act and the company's constitution, the duty not to engage in reckless trading, which means not allowing the business of the company to be carried out in a manner which is likely to create a substantial risk of serious loss to the company's creditors, and the duty to avoid incurring obligations unless you are satisfied that the company will be able to perform those obligations when required. So ensuring that directors comply with these duties can significantly reduce the risk of disputes, as it promotes transparent, informed, and responsible decision-making that balances stakeholder interests and ensures legal and financial responsibility. On the next slide, here we've got some more practical steps you can take in respect of your company to try to avoid director and shareholder disputes. So the first is investing in corporate governance. This means providing training to your company's directors and management staff once you grow to a certain size. This, of course, ties into the previous slide around directors' duties, as part of the training should include learning about those duties to make sure they're always front of mind. The next step is ensuring you keep accurate financial records for the company from the start. Clear records provide a factual basis for company discussions, which reduces the scope for misunderstandings about the company's financial position, and it also allows directors and shareholders to make well-informed decisions about the company, not to mention helping to ensure you don't fall foul of any of your tax or accounting obligations. We always recommend putting company governance documents in place. The base for this is a company constitution, and then once the company has more than one shareholder, a shareholders agreement as well. Well-crafted governance documents help to reduce disputes by clearly defining roles, procedures, and mechanisms for decision-making in respect of the company, as well as dispute resolution and in respect of company operations. Having these documents in place therefore minimises potential ambiguity that might come up and scope for disagreement. Finally, we always suggest having employment or contractor agreements in place. And really, this is in respect of all people that work for or provide services to the company, but in particular, for the purposes of this webinar, any directors or shareholders that are also employees. This ensures that expectations around what each person is required to deliver for the company in that capacity is clearly defined. I'll now pass back over to Jodie to talk about what you should do if a dispute arises.
Thanks, Nina. So if you've got an inkling that there's a problem, it might be really obvious. You might have had a big blowout with one or two of the other directors, or you might just have some quiet concerns about the way another director has been conducting themselves, and you're not quite sure what to do. It's a really good idea to seek legal advice. It can give you an idea of what the parameters are, what the options are, any precautions that you need to take to avoid any potential legal claims. Sometimes the stakes can be quite high when it comes to directors duties and the risks of yourself being in breach. One thing that we find quite difficult to, and is a difficulty in dealing with these type of disputes, is the potential conflict of interest. So where we have a dispute between the directors and shareholders within a company, but particularly within the directors, as lawyers, we can't act for the company and then have an action against one of the other directors. There's a conflict of interest there because all of those directors are part of that decision-making of the company. And so in that case, it's best if the individuals have their own legal advice as separate from legal advice given to the company as a whole. That's something that a solicitor can discuss with you, and it can be a little bit case by case depending on what stage the dispute might be at or what other circumstances are going on. The other thing we always say is that if you have some concerns and you have a constitution and a shareholders agreement, pull them out and have a look at them. If things have been running smoothly, you might not have needed to look at these in detail for a while, or you might not have needed to go to these type of clauses that can be relevant when things are tricky. So look to see if there's a dispute resolution procedure, which is often included in many agreements, and that can help guide you through usually a structured meeting and discussion process for the parties to try and work through some options together. Consider if it's the case where one director is behaving in a way that's very problematic, if it's an option to simply remove them with votes, separate to any employment law implications there are if they're also an employee. Likewise, if they're a contractor with a contract protecting their terms of engagement. But if on the basis they're only a director, there are circumstances where you can remove a director. If it's not set out in the Constitution or shareholders agreement, then the rules in the Companies Act will apply. The other thing to do, and this is very dependent on the personalities, the type of dispute, who you're dealing with, but it's a question we always talk to clients about, is where is the relationship at? Are you on speaking terms? Do you have a good personal relationship? You know, is an initial conversation an option to try and clear the air or put your concerns on the record is always a good idea. If you are able to do that in a conversation, it can be helpful. Always take notes so you've got a record of what was said. But otherwise, it's a good idea to put that in writing with the help of a solicitor if you have spoken to somebody, to set out what your concerns are and what actions you might propose to try and resolve the dispute. I hand over to Nina now to talk about some resolutions for director disputes.
Thank you, Jodie. So despite the complexity of these types of disputes, there are really only two ways that they can be resolved, one of which is by agreement between the parties or by court order. There are a few dispute resolution options you can utilise to help facilitate an agreement being reached between the parties. And as previously mentioned, often the company's governing documents will prescribe a process that needs to be followed, so it's always important to check there first. The three key options are negotiation, mediation, and arbitration, which at a high level offer progressively more formal and structured approaches to resolving a dispute. The first step of negotiation, which is akin to what Jodie was just talking about, is when the parties attempt to resolve the dispute through direct discussions between them. Where this is not possible or the parties are unable to reach agreement on their own, mediation can be utilised as a next step. Mediation involves engaging an independent, neutral third party to act as a mediator between the parties to help facilitate an agreement without the parties needing to go to court. The sorts of resolutions that can be reached through this process might include the following: splitting out the company assets and/or intellectual property ownership as between the parties, making payouts to one of the parties, which is potentially buying one out where it's a shareholder that's involved, putting restraints of trade in place on the parties, which might prevent them from engaging in competitive behaviour, applying confidentiality and non-disparagement obligations on a party, so preventing a party from sharing confidential information or saying things negatively about the company at issue, And each of these terms would typically be captured in a confidential deed, which would set out the terms and conditions of the agreement reached between the parties. The third form I mentioned is arbitration, which is another form of alternative dispute resolution, which involves an independent arbiter who hears the dispute and gives a legally binding determination to the parties. So that means that they are bound by whatever the decision is that the arbiter hands down and must comply with the order that's given. This option is cheaper and quicker than going to court. The final point there is around valuation for resolution. We note that any dispute resolution process will often require an independent valuation to be acquired for the company. This valuation gives the parties a guide as to the market value of the company and therefore each shareholder's respective shareholding. So being armed with that information can help to inform any potential solutions to the dispute at hand. I'll now pass back over to Jodie to talk about going to court.
Thanks, Nina. Well, as we've both said, going to court should be a last resort in these type of matters. We often have clients come to us and haven't had experience in the litigation process and think that going to court, might be a quick and effective way to remove a director or make some sort of claim against another director. And sometimes it is the only option, but it is worth exploring all of those items that Nina just discussed first, to see if you can find a resolution without going to court. If you do need to go to court, if you've tried those options and nothing's worked and you're stuck with a dispute that is particularly cases where it's stopping the functioning or the operation of the company. We see that quite a lot with clients who come to us. They're not able to function business as usual and the company might be losing money and they need to take some action and legal options might be the only way. The type of legal claims that can be made might be a direct claim against the other director in relation to what they're doing. It might be for oppressive conduct, as I mentioned before. Sometimes there's a type of claim called a derivative claim where it's more appropriate for the company to take action against that director. But as an individual director, you can seek the court's leave to step into the shoes of the company. So you can instigate and drive that claim against another director. You can see where it gets quite complex legally, and these are quite complex matters to run. There are a lot of legal considerations for lawyers to assess if you've got the basis to make a claim against the other party and how that might be run. It's possible to make multiple claims at the same time and within one court proceeding, and you can ask the court to make multiple orders. The other thing that we would say is that courts often require parties to engage in mediation or some form of settlement process before they go ahead. If you file a claim in court and the other side files a defence or a response, the court might then make some orders to send the parties off to attend mediation with a formal mediator. And even if you've had a go at that before and it hasn't worked, courts know that the cost and time of going to court can be very onerous on parties and isn't often the best way to get a resolution. When we say mediation, and I should just add this just to explain it in a little bit more detail, what we're talking about is an out-of-court settlement or a commercial settlement. And often it's the case that you might have a strong legal basis to make a claim against another director. Perhaps they have been misappropriating funds. But sometimes we'll say to clients, what's the main outcome here? What's your main goal? And it might be very clear that for the future operating of the company, the best outcome is to remove that director. And sometimes the best way to do that is to offer them some money. So you make a commercial offer. If they're a shareholder as well, that offer might be a sum of money, and in exchange for which they'll transfer their shares back to you or the other directors or the company. They'll resign as a director and they'll exit. And it would usually be then captured in a deed of settlement that ensures neither party can make a claim against each other, and it gives things some finality and some ending and some certainty. So when we talk about an out-of-court settlement or mediation, that's the process and that's the result. However, if they don't work and we're back to going to court again, what are the outcomes that might result from going to court? Well, they're less flexible than negotiation because the court will have discretion as to what orders are made at the end. For example, it might be the court might make orders that one party sells their shares to the company for a price fixed by the court. The court might rely on a valuation of the company that's provided, would usually be provided at some stage during the evidence process. The court might look at the parties having their dispute in the courtroom and consider that the company, that they're not in the best place to stay and manage that company in the future. And the court may make orders to appoint a receiver or wind up that company. That's worth considering if you go to court thinking that you're going to get a certain outcome that might penalise or punish the other director or remove them and leave you in charge of operating the company, then it might not happen that way. So that the court will have ultimate discretion. When we say court should be a last resort, what we're really talking about is the downsides of going to court. As I said, these type of claims are very complex to run. You need a solicitor. The solicitor will need to engage a barrister or who's the expert solicitor, it's a type of solicitor who appears in court, makes the argument, presents the evidence. So you've got a legal team to run a claim like this. Your total legal costs will be well in excess of $100,000, which sounds a lot, but if you consider the volume of material that's going to be required to prove to the court whatever the matters are that you're claiming as to the other director's conduct. And the court process takes a long time. So from the time you file a first claim until the other party files their claim, the parties prepare and file their evidence. And then finally there's a hearing. The hearing might be 1 day or it might be 3 or 5 days, depending on how many witnesses are required. That whole process is not done in less than 6 months. In fact, it usually takes more like 12 months or 2 years. So that's where the cost and the time and, of course, the stress comes in, and that time being taken away from the business as well. The other thing that's worth mentioning once legal proceedings are involved and is the risk of statutory penalties for directors. So you might launch a legal claim against another director because you're concerned about their conduct. What we often see when these matters go to court is some mudslinging in the other direction. And there's often different versions of events of what's gone on in the management of a company, and you might end up facing your own claim. But the outside of that is that the court can issue statutory penalties against directors for criminal conduct and fines if they're found to have breached their duties. It's not common in small business in our experience, but it certainly remains a risk. And if any particular conduct, such as misappropriating funds is very problematic, then that's the type of thing that can happen in court. That's the end of our formal webinar presentation. I'll hand over to Nina for some last bits and pieces, and then we can help answer some questions at the end.
Great. Thank you, Jodie. So as Jodie said, that brings us to the end of the main content. We hope you found it informative. You might also find our free publication shown here helpful, which is on New Zealand directors' duties. You can download it from the Resources tab or by scanning the QR code that's on the screen here. We also have an upcoming event that may be of interest. It's on protecting your brand, the most commonly asked questions about trademarks. And that will be held on Wednesday, the 2nd of October at 1 p.m. New Zealand time. If you'd like to register, you can do so via the link that's on the screen here. So before we get to our Q&A, a few words on LegalVision membership. This is a cost-effective alternative to have all of your business as usual legal needs covered. For a fixed monthly fee, you'll not only receive cost certainty, but all-inclusive benefits, such as unlimited document drafting and review, which includes all of your commercial contracts, unlimited legal advice consultations, which means you can book as many meetings with us as you need to discuss any of your business as usual legal needs. You can talk to any of our lawyers depending on the need, which includes corporate, commercial, franchising, employment, and disputes. Membership also offers unlimited trademark registration, and that's all for one very reasonable monthly fee, with options to purchase extra credit towards complex matters and ongoing disputes, which are charged on an hourly rates basis. I'll now pass over to Jodie to go through some of the questions that have come up during the webinar.
Thanks, Nina. If anyone has any other questions, please feel free to add them. We will get through as many as we can, but we've got a few here to look at to get us started. One of them, we weren't 100% sure exactly what was being asked, but we're making an assumption that it was, how are directors accountable for company affairs? The answer is, and we covered this in terms of the director's duties, the director's legal duties, which form part of the obligations of being a director. And I think we're often surprised to come across directors who aren't fully aware of what those duties are. And they're a very big obligation, and it's at the heart of it is understanding that whether it's a small company or a big company, as a director, you have to be have a detailed understanding of the company's financial position. If it's a small company, you can't leave that to the other director. You need to be across that detail as well. You might divide and conquer in terms of which particular tasks that you cover day to day. Or if you're a larger company, there might be a manager or an employee who has the day-to-day work of managing budgets and finances. But as a director, as a registered director of a company, you need to know what those numbers are at the end of the day. So it is your responsibility to ensure that you're provided with reports, that you fairly regularly review the company's finances, most importantly, so that you know if the company is tracking okay, if the decisions that are being made are in the company's best interests, and if not, if the company may be having some solvency issues, and if that's something that as a director you should be looking to get some advice about. Nina, did you want to choose one of the other questions to take on?
Sure, thanks Jodie. I'm looking at the questions and we have, can we remove another director if we think they're taking company funds? Thanks for that question. So the answer to that is maybe. So if you have a shareholders agreement or constitution, again, that's always the first place to go when you are wanting to make a key decision in respect of the company, to see what those documents say about how those decisions need to be made. So often we would always expect there to be director appointment and removal clauses contained in either one or both of those documents. So you would refer there and see what they say about how that can be done. So often, sometimes it might say that it's a majority of the existing directors, or sometimes it's shareholders that have the right to appoint directors, and then removal will occur in the same way. So if it's a majority vote that needs to take place, as long as you have the support of that requisite majority, then you will be able to remove the director at issue. If not, you'll have to pursue different options. And if you don't have any of those governing documents in place, then it will be the Companies Act that you look to. And under the Companies Act, it requires an ordinary resolution, which is 50% of the shareholders. So again, provided you have that support, you'll be able to remove the director at issue. Anything to add on that one, Jodie?
No, that sounded great. One question that we had pre-submitted is, what is the liquidation process if there is a deadlock between shareholders? As I mentioned when I was speaking earlier, this is something that we see quite a lot in very small companies. Now, as lawyers, we aren't liquidation experts, but it's obviously something that we deal with on the fringes of a lot of disputes when companies are struggling. What we do very early on is recommend that companies, being the directors, get some advice from an insolvency practitioner. They have very particular expert knowledge to advise on what the options are. And the liquidation process really falls into two types. And one is whether or not the company is solvent or whether or not it's insolvent. But also it depends on the makeup of the company, how many directors and shareholders you have. And in a case where you've mentioned there's a deadlock, then you can't unilaterally decide to put a company into liquidation. So a first step is to speak with a liquidation specialist. You might also need to be speaking to your lawyer about all the different circumstances as to that particular company's makeup, how the company is trading, and whether or not there's any option for agreement between the parties without going to court. That might be an opportunity to have a mediation or some settlement discussions with parties about what the future of that company might look like. For example, if there's one shareholder who's unhappy, you might be able to, as I said earlier, make them an offer to buy them out, for them to leave. There's a whole lot of options you can put on the table, but without the agreement, usually of the requisite number of shareholders, you're not able to unilaterally decide to wind up the company. If it's insolvent, that's different, and that's where you can get some advice. So a messy answer, sorry, but it's very much dependent on the circumstances, and that's where it's a good idea to get the experts to give you some advice. Nina, feel free to take the next question.
Cool. Okay. So I'm just looking at a question that's just come in, which says, what decision making would you recommend was undertaken at shareholder level as opposed to the director level for a small business, i.e. when do you go to shareholders? Which is a great question. There's a few different things to consider here, one of which is that certain decisions are prescribed to be director decisions versus shareholder decisions by the Companies Act. So that's one thing to always keep in mind, to refer back to there to understand, what needs to sit where. I would say at a high level, directors are responsible for the day-to-day management of the company, setting the strategy of the company, where the company's going, all the sort of financial oversight, reporting, appointing of senior management, and making sure that the company is compliant with all of its legal obligations, whereas the shareholders are responsible for sort of more significant key decisions, such as usually appointing and removing the directors, any sort of major changes to the company structure or the direction of the business. If there are any sort of significant transactions, usually defined as something that's more than worth more than half of the company's value, that's something that the shareholders would need to approve. Changing the constitution of the company, so the rules that govern how the directors and shareholders make decisions and operate with each other, they would be responsible for approving that. And usually also any remuneration that is given to the directors. So the base position is what's in the Companies Act, and then the overlay to that is, you can always opt to elevate certain director decisions to shareholder level if it's so important to you that you want those decisions to be made at that level, but always trying to strike a balance between wanting to make sure that the directors are able to make decisions about the company and keep the company moving, and you don't want them necessarily to be hamstrung by needing to get approval from the shareholders in respect of decisions which are really appropriately sat at the director level. So hopefully that answers the question. Can always follow up afterwards if not, and I'll pass over to Jodie to pick up another one.
Thanks, Nina. One question that we've had just emailed in is something that we get asked a lot in disputes that we're dealing with, and it is, when will a director be personally liable? The answer is very rarely. Well, again, two types of personal liability as a director. One is that you enter knowingly and willingly, such as signing a director's guarantee for a bank loan for the company. We see, even among some very sophisticated clients and directors, we consistently have directors think that any ongoing liability under a personal guarantee will end if the company goes into liquidation or if they resign as a director. And unfortunately, that's not the case. So it's really important to be very mindful that any personal guarantee is ongoing until whatever the obligation, the financial obligation that it is covering, ends, regardless of what happens to the company. In fact, personal guarantee is usually there in case the company falls over. So that's one liability. But more to the point of what this question's asking, I think, is in a legal claim, so in a court dispute or a dispute between directors, if one director is behaving in a way that is not in the best interests of the company, maybe they're entering some contracts or making some business decisions that aren't great, maybe they're actually helping themselves to the bank accounts or the company funds in a way that's not approved by the other directors. They can be found personally liable. It can be quite difficult. I know from a number of larger disputes that we've had go through court, these questions come up and directors are very, very keen to see other directors punished. It can be quite difficult to prove in a case that a director was personally liable to an extent that it meets the threshold that the court requires, whether or not that's what we call pierced the corporate veil, which is usually that directors are protected by that corporate veil and that any liabilities of the company are not theirs personally. But to put it very, very simply, in cases where an individual director has acted in a way that is particularly damaging, potentially criminal or fraudulent, then courts may be able to consider them personally liable for debts or damages incurred as a result of their conduct. So that's only something that would be found as part of a larger legal process, and it's not straightforward. Hope that helps. Nina.
Thanks, Jodie. We've got a question here which says, it's coming from an ex-director who's resigned from a company but is still a current shareholder in the company. The current director has run the company affairs to the ground and is trading the company as insolvent. Can this be a basis for any dispute or claims, as current director is shifting blame to the ex-director on the current situation of the company? So my first thinking is this will probably be quite, fact specific and would probably be worthwhile to have more of a chat to understand more of the details of what's going on. But I would say that trading the company as insolvent is absolutely a breach of a director's duty. And so on that basis, there is a claim there. And I would also go back to what Jodie was talking about earlier in the presentation about shareholder rights and potential derivative rights, to say that, there's been oppressive action against you in sense of the company being operated in a way which is impacting its value and therefore impacting the value of your shares negatively. So there's potentially something there. Would you like to expand on that, Jodie?
No, I agree. I think it's very, very fact and circumstance dependent, this one. It looks like the type of claim that we see a lot of. Ultimately, it's the current director's responsibility to be taking any action, and you're entitled to have an opinion and raise concerns as a current shareholder, not as an ex-director. And yes, it certainly looks like one where the company needs some advice as to the options. But if they're insolvent, that may be one. It looks like that you need both legal and insolvency advice, I'd say, to untangle all of the issues there. And maybe we've got time for one more question. I'll see how I go. This is something that we get asked a lot. Again, we see a lot in many of the director and shareholder disputes that we deal with in the disputes team. And the question is, I'm a director and a shareholder and I want to leave the company. Can I get my original investment back? And the answer is not necessarily. But this is something, again, we see in much smaller companies where things haven't been done perhaps as formally and in a structured way that we might see in larger companies. And perhaps, you know, two people got together to start a business and were putting some money in and probably not formalising things with documents and contracts along the way. But at the point that you want to leave, you don't have a clear legal right to take back all of the money that you put in. There are different things that we look at when we're looking at this. The first question is that was that money that you put into the company a loan, a director's loan, or was it an investment? And was it not otherwise characterised as a loan that you would be entitled to get back at a certain point? If it was a director's loan, is there a loan contract or any other contract terms written down anywhere or agreed between the parties to say when and how you would get the money paid back? For example, we quite often see situations where there's been a loose, maybe an oral agreement between directors that we'll both put this much money in and we'll get the money back when we start making a profit. And that's something that legally we can work around. If there's been no agreement that the money is a loan and it is an investment that you've put in for the working capital to get the company started, you're not entitled to get that back. We often see people also think that their shares must be worth the amount of money that they put in at the start. And that's also not the case. So the shares are worth what the company is worth at a particular given time on the market. So what the company's market value is, and therefore what percentage is your shareholding. And that's why when we have disputes, we nearly always end up recommending at some point that if the companies haven't had a recent company valuation, they might want to engage an accountant or a specialist to conduct one so that at a point in time, you know what the shares are worth. We often see people thinking their shares are worth a lot more than they actually are. The company might not be doing as well, or it might be still in a growth or a startup stage. So all of those investigations need to be done to work out what you're entitled to financially when you leave. And sometimes those discussions, as I've said earlier, can be had in an informal settlement conference. It might be, what amount of money are we prepared to exchange hands here to resolve everything between us and walk away? That's the last question. Hope we've been able to give you some helpful advice today. But if not, please do feel free to reach out and book a consultation or book in and ask us for any help. We're very happy to help, and all the best. Thanks very much. Thanks, Nina.
Thanks all. Have a great day.